Back on the record in State versus Brooks. May I have the appearances, please?
Just 1 second, I was certain I've been in here. I'm not sure if I even have everything. I apologize for that.
It's all right. When you're ready.
I'm here as third-party intervener in that matter, appearing as authorized representative for my client. I'll set for value in return for value all of the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and make a reservation of all of my constitutional rights, mostly the First, the Sixth, and the 14th Amendments.
The record to reflect that the individual known to this court as Darrell Brooks is present in custody in person. He is wearing his jail attire this morning. Then, of course, we are open and the jurors are here and they will be instructed to start their deliberations. The only other thing I would put on the record is I have received information regarding the Reddit post that there was a subsequent post from that website indicating that it was a prank. I don't know to what extent the Sheriff's Department is looking into that as well, but it's my understanding based on news reports that that entire post or site was taken down. Not the site of Reddit, but it's no longer, I believe, viewable. But there was that additional information regarding that, at least from the administrator, I believe, of that post. So I just wanted to put that on the record. Go ahead.
So it's being called a prank?
Per the Reddit post itself, yes.
So we don't have any idea if that's a fact, though, right?
You're correct. I'm just putting on the record the additional information that's been reported. So at this point, until there's a question or a verdict, courtroom will remain open. I'm going to be working in my office on other things and will be available, of course, if there are any questions or if a verdict is reached. So notify the parties.
Judge.
Yes.
Go ahead.
No,
Go ahead.
I'm still very concerned about this whole Reddit thing after having the chance to fully read it and look at some of the language that's in it. It's very concerning.
That's why there's an investigation, sir.
I would like Your Honor to, if it pleases the court and if it pleases Your Honor, I would like to look at some alternatives, if I may bring up in regards to the language. I also want to state that, for the record, that this did not come about from the prosecution side, from the defense's side, and certainly not from Your Honor's side. This is something that just pretty much sprang up. A lot of my concern, though, just not from just the language in the actual post, but I was kind of concerned that I was the last one to learn of this information that had been known. I wasn't aware of it until after 6:30 last night, or around that time, because I don't want to misquote the record, but somewhere around that time.
It was shortly after 7.
Oh, so it was after. I didn't know. I thought it was. I knew it was after 6:30, but I didn't want to incorrectly state the record. Your
I can
Honor,
address that for you right now if you would like.
yeah, if it pleases Your Honor, I would like to request some alternatives to this issue.
What's your specific request?
My specific request would be to look into a mistrial and also any alternatives along those lines, short of that or along those lines, or a mistrial. I was looking at some, obviously, yesterday was very, very long for everybody. And as you know, because of my status here in the jail, I'm allowed to have law library time up until a certain point of the evening, and then I have to shut it down per jail policy. So I was able to find a few different things that I wanted to bring to Your Honor's attention, if I may.
Go ahead.
One being United States versus Perez, 22 U.S. 579, and that specifically, I think it's referenced, because that one is pretty old in itself, but it's referenced in a lot of the other case laws that I actually found. I think, and I could be, if I'm interpreting this incorrectly, I apologize. They kind of use that as kind of like the benchmark for what they refer to as a manifest necessity. That's kind of like one of the leading cases that each one references in regards to issues similar to things like this when it comes into play, and it specifically points to trial judge's discretion, and I think that's kind of like the leading one. Also, I looked at Brown versus Rushton 572 F.3D 198, which speaks to language. Basically, it speaks to the same thing. It speaks about manifest necessity. It speaks about if there's an issue of exculpatory evidence, things of that nature. Also, United States versus Bates, that's Bates, 917F2D388, and that speaks of potential for an impartial verdict. Specifically, it says along the lines of partial verdict, if an impartial verdict can be reached, or if a verdict of conviction could be reached but would have to be reversed on appeal due to an obvious procedural error in the trial. That's one of the main issues that speaks to. I also looked at Arizona versus Washington, 434 U.S. 497, and that speaks to what I was stating before. It says neither party in a case has a right to have his case decided by a jury which may be tainted by bias, and I say that because it certainly wasn't anything dealing with the prosecution. They had nothing to do with this. The defense had nothing to do with this, and certainly you, Your Honor, had nothing to do with this. But just for the concern factor, the language, it's pretty clear that this, if not directly came from a juror who sits on this panel, it came from someone who sits in this courtroom every single day. The language, it directed towards you, Your Honor, directed towards having clear bias towards the defense. Some of the things that they quoted of having knowledge of is extremely concerning, extremely concerning. And then going back to some of these case laws that I cited, it talks about something to the effect of, you know, the ends of public justice. But I think that is leaning more so towards the judge's discretion, I would say, at least from how I was interpreting it. Obviously, I'm not educated in a lot of the laws in itself, but how I was interpreting it, this is definitely a concerning issue. It's definitely something that I would request Your Honor to take a long look at some options, look at some alternatives. And those case laws I cited talks specifically about that, options that you, Your Honor, can look at and use your discretion to see if it's appropriate in any way. But I'm extremely concerned about this. If anything, for cautionary reasons, I believe, Your Honor, that you definitely should take a look at everything I'm saying here in these case laws. And
what's the request, though, that you're making based upon the case law that you cite? I heard in there mistrial, but I want to make sure I understand your request for relief and what it is.
You say request for
relief.
Relief.
What are you asking me to do based upon the information the limited information we have about the Reddit post and this trial?
I guess my request would be, because of the concern of this, to look at a mistrial, or at the very least a discharge of the jury at this time, so this can be resolved. This is alarming, to say the least. This post, and I don't know what Reddit is, to be honest. I've never heard of it or used it, so I don't know the extent of. It's almost like this could be like a snowball type of thing. It can start with something that's this small, and then it can snowball out of control into something totally different. I don't know the extent of this website. I don't know I think the name of the person who sent who alerted the clerk, of course, to this post. I think his name is in the email. But then that even begs the question of, how did this person come across this site? What is their significance to this? What is their role in it? It's just so many questions, and I mean, clearly this points at the court's integrity. It points at your integrity, Your Honor. It's alarming. It's very alarming. And if there's a chance that there can be hidden bias in this jury, it needs to be addressed now rather than later. This is very concerning.
Well, thank you for bringing up your concerns. Let me turn to the state and I'll respond.
The original post was on a subreddit thread called Justice for Darrell. That's the copy that the defendant has in front of him. That post was edited last night, claiming that it was a prank from the start, and that the original poster didn't think it would get that far out of hand. The way that Reddit works, the only person who can modify the content of the original post is the original poster, and because the jurors have no access to any electronic devices, I think it's safe to say that our 12 jurors back there are not the original poster. So I think that puts that issue pretty much to bed. It's still obviously under investigation because the court takes it so seriously, but there really is no actionable or any real reason why we should doubt the jury's being unbiased in this case.
I object to that on the grounds, Your Honor, that, like you just stated, it's an investigation going on. And if there's an investigation, then that clearly says that something is amiss We have 15. We have 15 jurors. There's still too many questions that we don't know. Too many. I don't think anything's put to bed because we don't know. It's unfair to say that the issue was put to bed when there's still so many questions left out there. I'm sure you reviewed it yourself, Your Honor. You see the language in this, whatever it is, thread. I don't know. I don't know what this is. It's clearly a post from somebody who has intimate knowledge of the trial and what's going on in the trial. I don't think, common sense would tell you that this is someone who's very close to the case, whether they were intending to be funny, whether they were intending to try to prank the court or anything like that. We don't know. That could be anybody's guess. The language in this, the way that it's formatted, they lay out 4 specific points of what they think. They point to certain language in the case. They make references to saying when we were in the room, they got certain feelings from where they specifically refer to themselves and a group. That would be we, plural. They say, and I have to admit, I am biased against the defendant for the horrible acts he did. And they attack you, Your Honor. They clearly attack you. This is if this is someone's idea of fun, is anybody's guess, but I don't believe that it is, clearly by the way it's formatted and by the language that is in it. This is clearly someone with intimate knowledge of the case and what's going on. Clearly, there's no other way to interpret this. You can tell by what they're laying out in the language that they're speaking with, that this is clearly someone close to the case. And because of that, it still has to be, I'm informed of the investigation, but there's still too many questions left in the air just from this. How can we say anything's put to bed when there's still an investigation? For all we know, what if this turns up that it was someone on the jury, or what if it turns out that more people are involved in it than just whoever this anonymous person was who left the post? It's too many questions and it's too concerning. What if something like this springs up again at the last minute? We've been going through the trial now for basically 3 weeks, the better part of 3 weeks, and even in court days leading up to the trial, we've never had anything like this happen. Nothing like this has been brought to your attention. Nothing like this has been brought before the court's attention. This just came out of the blue, and now all of a sudden it's being labeled a prank. Is that because they were found out? It begs so many questions. It's too uncertain. It's too concerning, and it's too alarming. It's too alarming to just overlook and say, oh well, we'll just set it to the side and let them. No, there has to be some type of alternatives, and something has to be done. Something. And if that's a mistrial, if that's discharging a jury, if that's some other type of alternatives that can be looked at, I'm sure that these case law speaks to other options that could come into play. They deserve to at least be looked at, if anything, to protect the integrity of the trial. I find it very hard to believe that this close to the trial being over, and now all of a sudden these issues are being raised. So this is obviously not a prank, and it's obvious that this is someone with intimate knowledge. It's very clear to me.
Sir, I cannot make conclusions at this point about whether this is legitimate or a prank. What I know is as follows. I received the information about the subreddit post at approximately 9:30, 9:40 yesterday morning. I alone made the decision to withhold advising the parties because of where we were at in the trial, because there was nothing in that post. It was an anonymous post that would lend credibility to that it was in fact one of these jurors. But out of an abundance of caution, I referred it to law enforcement because it is very serious if the integrity of these proceedings were to be put at issue by a juror. I'd remind you, though, every single day these jurors were read the bulk of jury instruction 50. They all took an oath, and I have no reason to doubt that they would violate that oath at this time. So I made the decision to withhold telling the parties because we were in the middle of instructing the jury. I was in the middle of instructing the jury. And I wasn't going to delay the proceedings because it was so speculative at that point, and remains speculative. At this point, you've requested a mistrial. You've requested that I discharge the jury. I'm declining to do that at this time, sir. Again, I need to make decisions based upon the record that's before me. And right now the record is speculative. There are no facts to support a mistrial or discharging the jury. At this time, I do not see grounds for a mistrial. I do not see grounds to discharge the jury, and that is how I will address it at this point. I know the state, I believe, wanted to address something else. I'm not sure if that was it, but you had deferred to Mr. Brooks, so go ahead. Is there anything you want me to address or at least bring to the court's attention at this time?
Just a minor point, Your Honor. You had noted the defendant is in his orange jail uniform today. It's my understanding the jail did offer him the ability to put on his street clothes, and he declined, so I just wanted that on the record. There may be occasions where this jury has to be brought into the courtroom for one reason or another, and he should be in civilian clothes.
It's a good point to bring up. It is possible the jury would need to be brought out if there is any question that I need to answer on the record. So it is possible that the jury would need to come out. Of course, they'll come out if and when a verdict is reached. So I would certainly give you the opportunity, sir, if you want to change into the street clothes, that I would certainly direct the Sheriff's Department to make that available for you, should you choose.
Isn't it my choice?
Yes, it is.
So why do I need to be in street clothes? Why does that need to be on the record? That
your choice should be placed on the record, sir.
If not, I was offered to be in street clothes if I made it the choice.
Do you dispute that, sir?
Yes, I dispute it because it's my choice.
Well, no. Do you dispute that you were given the choice this morning?
At this point, there's no reason why that should be on the record. That if I was not offered street clothes, what relevancy does that have to?
Could have potential relevancy later on if we were to challenge that you and claim that you were required to wear your jail uniform or jail attire. You're not required. This is a trial. You have the right to wear street clothes, and I will certainly provide that opportunity should you wish to change at any point in time. But what you're telling me is it's your choice to be in jail attire. I'll respect that choice, of course.
So why does that need to be stated for the record?
I just indicated why, sir. So
I don't see the relevancy of it.
All right. At this point, unless there are any further issues, I am going to go back into my office. The courtroom will remain open, and we'll let you know when the jury communicates with us, either about a question or verdicts.
There is something that needs to be addressed. Subject matter jurisdiction.
The court declines that. I'm stepping off.
Why hasn't it been proven on the record yet? And I object.
State versus Brooks appearances are as they were before. I would make just one note that Mr. Brooks is now present in a suit, and I will also advise that at 9:43 a.m. this morning, I was advised that the jury had reached verdicts in this matter, and without anything further, I'll have the jury brought out.
Your Honor, I don't consent to being called that name and would like to address subject matter jurisdiction for the record as yet to be proven.
Your objections are noted and will not be addressing subject matter jurisdiction. Please bring the jury out.
Would it be proven for the record, Your Honor?
Just a reminder to everyone that I do expect everyone in the courtroom to demonstrate appropriate decorum and courtesy as the verdicts are read and refrain from audible responses. Any disruptions may result in removal from the courtroom.
Your Honor, is that a tacit agreement not to address subject matter jurisdiction for the record?
Jury's coming in. All rise, please.
I respectfully object to that ruling, Your Honor, and request the legal reconsideration of your ruling for the record.
Your requests are noted, sir. We will not be addressing that further.
For the record, may I respectfully reject that ruling and take exception to that ruling, Your Honor? Is that a tacit agreement and a judicial determination that you don't have to answer that question as a public servant, Your Honor? For the record, may I request the legal or factual basis for your ruling, Your Honor?
It might have been a false alarm.
For the record, may I respectfully request a written judicial finding of fact and conclusion of law on this issue, Your Honor?
All your requests are noted for the record. They all are denied, sir. All rise. Jury's coming in.
For the record, may I respectfully move for an interlocutory declaratory appeal on this matter, Your Honor?
Denied.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction?
Denied.
Based on what law or fact, Your Honor? Is that a tacit agreement that you don't have to answer that question? For the record, Your Honor, as a public servant, you don't have to address admiralty law or common law if this court is operating under admiralty law.
We will not be addressing any of those issues.
Thank
you, everyone. Please be seated. Ladies and gentlemen of the jury, have you picked one among you to be the foreperson? All right, and I see it's juror number 11. Have you reached verdicts on all 76 counts?
Yes.
All right, would you please hand all of the forms to the bailiff?
Your Honor, seeing is that we've reached a verdict, is it necessary that I have these shock devices on my ankles?
That I have confirmed that there are 76 signed verdicts and 76 unsigned verdicts. All right, I will read each one into the record. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 1 of the information, dated this 26th day of October 2022, signed by the foreperson, juror number 11. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 2 of the information. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes.
Burn in hell, you piece of shit.
Hey, you are to be removed right now. You will not do that. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 3 of the information. Guilty of first-degree intentional homicide as charged in count 4 of the information. Guilty of first-degree intentional homicide as charged in count 5 of the information. Guilty of first-degree intentional homicide as charged in count 6 of the information. Guilty of first-degree recklessly endangering safety as charged in count 7, guilty as charged in count 8, guilty as charged in count 9, guilty as charged in count 10, guilty as charged in count 11, guilty as charged in count 12, guilty as charged in count 13, guilty as charged in count 14, guilty as charged in count 15, guilty as charged in count 16, guilty as charged in count 17, guilty as charged in count 18, guilty as charged in count 19, guilty as charged in count 20, guilty as charged in count 21, guilty as charged in count 22, guilty as charged in count 23, guilty as charged in count 24, guilty as charged in count 25, guilty as charged in count 26, guilty as charged in count 27, guilty as charged in count 28, guilty as charged in count 29, guilty as charged in count 30, guilty as charged in count 31, guilty as charged in count 32, guilty as charged in count 33, guilty as charged in count 34, guilty as charged in count 35, guilty as charged in count 36, guilty as charged in count 37, guilty as charged in count 38, guilty as charged in count 39, guilty as charged in count 40, guilty as charged in count 41, guilty as charged in count 42, guilty as charged in count 43, guilty as charged in count 44, guilty as charged in count 45, guilty as charged in count 46, guilty as charged in count 47, guilty as charged in count 48, guilty as charged in count 49, guilty as charged in count 50, guilty as charged in count 51, guilty as charged in count 52, guilty as charged in count 53, guilty as charged in count 54, guilty as charged in count 55, guilty as charged in count 56, guilty as charged in count 57, guilty as charged in count 58, guilty as charged in count 59, guilty as charged in count 60, guilty as charged in count 61, guilty as charged in count 62, guilty as charged in count 63, guilty as charged in count 64, guilty as charged in count 65, guilty as charged in count 66, guilty as charged in count 67, guilty of hit and run as charged in count 68. Did the accident involve death to Virginia Sorensen? Answer, yes. Guilty of hit and run as charged in count 69. Did the accident involve death to Leanna Owen? Answer, yes. Guilty of hit and run as charged in count 70. Did the accident involve death to Tamara Durand? Answer, yes. Guilty of hit and run as charged in count 71. Did the accident involve death to Jane Pulick? Answer, yes. Guilty of hit and run as charged in count 72. Did the accident involve death to Wilhelm Hospital? Answer, yes. Guilty of hit and run as charged in count 73. Did the accident involve death to Jackson Spark? Answer, yes. Guilty of bail jumping as charged in count 74. Guilty of bail jumping as charged in count 75. We, the jury, find the defendant, Darrell E. Brooks, guilty of battery as charged in count 76 of the information dated today's date and signed by the foreperson. Mr. Brooks, would you like me to poll the jury?
Yes.
Members of the jury, I'm going to ask each one of you individually to stand up, identify your number for the record, and then state whether the verdicts read in open court are your true verdicts. I'll start with the foreperson. And I'll read your numbers first so it's a little bit easier. So juror number 11. Were the verdicts read in open court, or are the verdicts, let me rephrase that. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 3. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 6. The verdicts read in open court, are those your true verdicts?
It is.
Thank you. Juror number 14. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 19. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 27. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 34. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 41. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 45. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 46. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 48. The verdicts read in open court, are those your true verdicts?
They are, Your Honor.
Thank you. Juror number 51. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. I should state for the record, I did have the alternates brought back in. Obviously, they did not deliberate, but it was important to have them because there are certain instructions I give at the end. All right, Mr. Brooks, are you satisfied with the polling of the jurors?
No.
I'm sorry?
No.
The court is still satisfied with the polling of the jurors. The court now accepts the verdicts. Ladies and gentlemen, on behalf of myself, the citizens of Waukesha County, and both parties here, I want to thank you for the time and attention that you've spent on this case. Your service in this case is now concluded. There is no requirement that you maintain secrecy concerning what happened in the jury room, but you do not have to discuss the case with anyone or answer any questions about it. On behalf, again, of the court and all of the parties, we thank you for your service over the last 3.5 weeks. You are discharged and free to go. All rise for the jury, please. Thank you. Be seated. Anything from the state at this time?
Your Honor, the state moves for judgment on the verdict as to each and every count.
Anything from you, Mr. Brooks?
What is judgment?
Given the verdicts from the jury here today, the court will enter judgments of conviction based upon the verdicts on all 76 counts. The court will also revoke bond. In this case, I plan on bringing the case in Monday this coming Monday, the 31st at 1 p.m. to address further scheduling. What I would ask the parties to do between now and then is to determine how long you think each side will need to present their sentencing remarks, whether you anticipate anyone speaking on your behalf, if so, how many, how long, so that I can then look at my calendar and adjust and make sure that I have the appropriate amount of time to do that. I'm not going to sentencing on Monday. It is just for further scheduling at 1 p.m. before my afternoon calendar.
Judge, would you be willing to consider persons appearing by Zoom for sentencing?
Yes, I would not do anything different than what I've been doing since we started utilizing Zoom, and that is to make it available for both victims and family members of the defendant if they so choose to make statements over Zoom.
Okay, thank you. That
You're welcome.
helps us in our planning.
All right then, thank you everyone. We are adjourned for today. We'll see you all on Monday.